Hi, my name is Matt Eurich, and I'm an attorney here at the Mindell Law Firm, where we focus the majority of our practice on auto negligence cases and premise liability claims. When a client first comes into contact with me, the most common question that I get asked is, do I have a case? I always tell my clients during the initial contact that I do not know if they have a case because there are a number of factors that go into determining if an injured party has a viable claim. While each client's claim is very different and present a unique set of facts, there are always three things we look at initially here to determine if a client has a viable claim. Whether it's an auto case or a premise case, we always must look for number one, insurance, number two, liability, and number three, the damages. This may seem pretty straightforward, but whether you have an auto claim or a premise claim, a client can face hurdles from any of the three factors above. I'd like to start by looking at auto cases and how we apply the three factors. With an auto case, we first look at liability in determining if a client has a case. Liability is simply about pinning fault on the other driver you were involved with in an auto accident. We will determine liability by obtaining a copy of the police reports. If there are any discrepancies in the report, we will contact any listed witness to help determine fault for the accident. If the report is clear and it appears that the fault will not be disputed, we move on to the second factor, which is insurance. The easiest avenue here is that the at-fault driver had insurance on his or her vehicle, which leads us to setting up a claim with their insurance carrier. However, we do run into instances where drivers are either not insured or they do not have adequate coverage for your injuries. If this is the case, then we must look to your own insurance policy to see if you have what's called underinsured or uninsured motorist coverage in order to proceed with the case. If we do find valid insurance coverage in place at the time of the accident, we then look at the final factor, which are damages. For an auto case, the damages can be the toughest thing to prove and the most time consuming because in Michigan, there's a threshold that must be met in order to pursue a claim. For example, if a client breaks his leg in an accident and is taken directly from the scene of the accident to the hospital and has surgery, the insurance company will have a very difficult time contesting causation and damages. However, a large majority of individuals injured in an auto accident do not begin to experience symptoms from their injury until well after the accident. This could be a day later, a week later, or even many months later. When this is the case, you can be sure the insurance company will argue that whatever damages you are claiming are unrelated to the accidents. This is why it is vital for every client to follow up with their doctor and continue following up as long as their problems persist. For a premise liability case, the insurance and damage component are mostly the same as they are for an auto accident. If we can confirm insurance and relate damages to the incident, we have two of the three prongs satisfied, and premise cases do not have a threshold. The biggest obstacle by far in premise cases in Michigan has to do with liability. Every single premise case has a unique set of facts, and until we know exactly what happened, it is very difficult to know if a client has a case under current Michigan law. Unfortunately, Michigan law is extremely premise owner friendly, so we have to collect each and every fact to determine if there is a viable claim. While there are other factors that go into determining if a client has a case, if we can determine there is liability, insurance, coverage, and damages related to the incident, this will go a long way into determining if a client has a case. Thanks, and please give us a call if you have any questions.